Hello, this is Rylan from Joseph and Hall. I'm double checking whether our stream is working properly.
It's been a while since we've done this, so please excuse any technical issues as we move forward with our Facebook Lives.
And it's working. We're good to go. So, hi everyone. My name is Rylan Warner. I'm here with Zachary New and Aaron Hall, two of the partners at Joseph and Hall, and we're here just to provide a quick update on the Biden Parole in Place program that was announced last week, and to kind of hypothesize. We're still waiting some additional clarification and details on that program, but we thought maybe we could talk about how we could see it affecting people or helping people in certain situations. So would either of you like to jump in first?
I'll jump in with this Department of State and DACA section of the announcement. We're hearing a lot about the parole in place part of this, and it's really exciting, and we do want to get that information out there. But I don't think we're talking enough about that second piece of the fact sheet, which is really for DACA and high-skilled immigrants is really what it's focusing on. I put a video together on Friday, not sure if it's out yet, about how this announcement impacts folks who have DACA. The bottom line there is it doesn't really seem to impact folks who have DACA or other dreamers any more than it would anybody else who has a higher degree of some sort. The program was announced on the 12th anniversary of DACA, and so it seemed like they were really just trying to throw dreamers and DACA in there somewhere. So there's not really a DACA-focused benefit or anything like that we're seeing. But there are some cool new benefits that seem to be in the works for folks who have higher degrees and will be seeking work visas in the United States. Like Rylan mentioned, we're still waiting on a lot of the details on what that's going to look like. But it really seems like it's going to be expedited processing at the Department of State level at minimum. And especially we're going to see some expedited processing of waiver applications for people who have certain grounds of inadmissibility against them. I'll put together a video that's a little bit more in depth about what those waivers look like and I guess what the qualifications are for them. But from a very high level, if you're inadmissible to the United States, meaning you're ineligible for a visa for, let's say, a criminal conviction, a Department of State consular officer can recommend that ground of inadmissibility be waived. Essentially, it's forgiven and allow you to get that visa, even though you have this ground of inadmissibility that would otherwise render you ineligible for that visa. It does go through a pretty lengthy, I guess, processing, kind of logistical hoops that there's a lot of jumping around between agencies, I guess is how I put it. It starts with going first to the consulate where you apply for the visa, and the consular officer finds you inadmissible. Then the consular officer has to recommend that you get this waiver. Then they send it back to the U.S. Customs and Border Protection, who then adjudicate the application and send it back to the consulate. So, it is a little bit of a lengthy process, and that makes it kind of exciting that there's this potential expediting of it, which will make people get their visas faster and get back to the United States and get to work much faster than they would otherwise. But now the bottom line, I think, for folks with DACA is that it's not something you should focus on as if you're getting some sort of special treatment as having DACA, just that you could potentially benefit from this benefit that's more widely available.
Yeah, and I think turning to the parole program, like Zach said, that has gotten a lot more attention. This is the parole for spouses of U.S. citizens, and I think the word parole is not really common to this kind of situation, so people might not know what it is. And in this context, what we're talking about is basically a document that acts like a lawful entry, even though a person is already here in the United States. It acts as if they had, or it stands in place of a lawful entry document. And why is that important? Well, there's two reasons. I think first, somebody who has parole can get a work permit just by having parole. So they get protections from deportation and they get authorization to work in the United States. probably more importantly, a requirement for applying for adjustment of status based on a family member's petition in the United States is that you have been inspected and admitted or paroled into the country. And so once you have this parole, then you meet that requirement and you can apply for your green card here in the United States, where otherwise you would have had to go abroad and get a waiver and then come back. And as lots of people might know, and we know all too well, the waiver process takes many years. We're talking about kind of 4 years, I would say, on average for the I-601A waiver for unlawful presence. And so this just cuts that requirement out for lots of people. I think one of the things to consider is how this is going to affect cases in different postures, because lots of people have already started a process towards getting a immigration status for their U.S. citizen spouse, or for their non-citizen spouse, where they have a U.S. citizen spouse who's the petitioner. And so I thought maybe we could walk through a couple of those scenarios and talk about what it looks like. So Rylan, maybe I'll pass it to you with this question. How would you think that this would affect your case if you were an applicant who had an unlawful entry, but has already had a I-130 petition by the U.S. citizen spouse filed?
So if you already have the I-130 filed and you have that unlawful entry, you are basically in the first stage of trying to get to your consular appointment. And the whole purpose of this program is to cut out that consular appointment. So you have that I-130 pending, you wait for that to be approved. Well, really, we're going to go for the parole in place before we wait for that I-130 to be approved, but that would be an essential step in this process too. So you are definitely eligible for this program. You should look into what are the requirements needed to apply for the parole in place program. Again, those details are still being revealed, but you should reach out and schedule a consultation with an attorney to say, hey, this is what I'm thinking about doing. You know, I have a U.S. citizen spouse. They already filed an I-130 for me, and our plan was to do consular processing. Can we take advantage of this route instead? Yes, if it all pans out, you definitely should be eligible for this program. One video that I actually made today is, when should I be hiring an attorney for this process? Because the details still are kind of unknown, but I recommend, and I'm sure everybody on this call recommends, having a consultation at least with an attorney as soon as you can, so that you are on their radar. And when all of these details are starting to emerge, we can start getting this parole in place application together for you as soon as possible, because we want you to be the first person in the door for this type of application. We don't know what kind of challenges will be brought against this program, how long it'll be running for, but we want you number one in line so that you can then be approved for it as soon as possible, and then bypass the whole consular processing part of it too. So all that to say is, if you're in that spot right now where all you have is the I-130 pending, but you're thinking this is the route you want to go, then you are eligible for this program most likely, and you should talk with an attorney about the details.
Yeah, and I think that one's maybe the easiest call, as far as like, yes, you should go through this program if you can. Where you start getting people who are further along in the existing processes, maybe there's more of a discussion that has to happen about what makes sense. So, for example, some people already have filed their I-601A waivers and they're pending with USCIS. Or some people might have their I-601A waivers approved and they're waiting on an appointment at the consulate. And some people might already have an interview scheduled at the consulate. So I would say, if your I-601A waiver is pending, it might be a little frustrating because you've already probably spent a lot of time and resources and probably money getting it filed, and you did a great job, and you're just waiting for the approval, and now you might find out that it's not necessary. However, it's still worth considering switching tracks here and doing the adjustment of status after a parole, because it could be much faster, and it eliminates the risk of travel abroad to a consulate, where a consular officer can, and we have seen it happen, it's not common, but they can make new inadmissibility findings and cause a lot of problems down the line. The other thing is, like I said, we haven't seen the details yet, and we'll wait to see them come out, but my expectation is that you will get a work permit with the parole. And so while you're waiting for an I-601A waiver, there's no work permit associated with that wait time. But with this process, my expectation is that there will be a work permit that you get while the rest of the case processes. So that's a big difference. Kind of reinforcing what Rylan said about when to see an attorney, when to start putting stuff together. I was telling these guys, I think last week, that I think in a lot of circumstances, like a lot of new programs, it might make sense for some people to just kind of wait, see how it plays out, then file after we start getting some experience. To me, for most people, that's not the situation here. I think there could be real advantages to being one of the people filing on day one that they accept applications. And I just wanted to kind of discuss what that timeline looks like. So what we know from their announcement so far is they expect to accept applications starting sometime in late summer. That's not defined, but let's say that's maybe August. And that leaves the rest of 2024 and into January 2025 before Inauguration Day. And on Inauguration Day, we may have a new president. We don't know. But if we do, former President Trump has promised already that he's going to rip up this program, that it's no longer going to exist. But for people who may have already gotten approved, if they're approving these fast enough, you can't undo the approval in some ways. And that is because the statute for adjustment of status says that a person has to have been paroled. So it's past tense. So once you're paroled, you can apply for adjustment even if the program no longer exists, even if it gets canceled. So there are real potential benefits where an early applier might get to adjust status, whereas somebody who waits 2 weeks, a month after the program starts in earnest and then applies, maybe it doesn't get approved in time for that. So I just think that anybody who can take advantage of this and change their path should really consider filing on day one. And to file on day one, I mean, we're already at the end of June. If we're talking about August, I think it's time to start gathering documents, start consulting with an attorney, start putting stuff together, even though we don't have all the details. Because if you're still chasing after documents, after trying to document your presence in the United States or any criminal convictions or traffic stuff that you might have that you want to document with this, and you start bleeding into September or October, you're really jeopardizing whether you have a chance to benefit from this.
And that doesn't even take into account that I am imagining there will be some court challenges over this at the very, very beginning. I mean, I think that a lot of the folks who have looked at this program, who are pretty respected legal scholars, think that it is very much legal, that the president's ability to do this is kind of inherent into his authority to regulate the admission of people into the United States. And so there shouldn't really be, I guess, a negative court finding against it. That's not to say that some court couldn't come out with a bad decision and say, we're going to block this program until I make a final determination on it. And that final determination takes 8 months or a year or however long it takes. So you could end up with maybe a month or 2 months of really a filing window, notwithstanding the election coming up. So definitely at least a consultation, I think, is a incredibly important step right now. There's just so much unknown and so much you could be doing right now to make sure that you've got kind of your ducks in a row when things are ready to go.
Yeah, and one issue that I've already run into with folks is wondering about the perm bar. So for some people that have accrued a certain amount of unlawful presence in the United States, departed the United States, and then re-entered without inspection, they are what's called permanently barred from the United States, and they actually have to spend 10 years outside of the U.S. before they can apply for an immigrant visa, which would get them a green card. And that has been a really big sticking point for a lot of folks trying to pursue immigration. They get stuck in this situation of, well, I'm married to a U.S. citizen spouse. I'm living here in the United States. I maybe have been living here in the United States for years and years and years, but I'm subject to this permanent bar that says I have to spend 10 years outside of the United States. And so some people in this situation are already wondering, well, can I use, I'm married to a U.S. citizen. Will I be able to use this program? And right now it's unclear. We are, at least it kind of seems like they might not be eligible for the complete road to the green card, but if, maybe they can possibly apply for the parole, if only for the ability to get the work permit, which would be awesome for those people in that situation. But really, it is just unclear, and we have to wait on additional details to be revealed about the program before we can say definitively one way or another about that. At least that's my understanding. Have you guys heard any differently lately? Okay.
No, what I saw was like an initial announcement that said that you had to be otherwise eligible, and then for adjustment, which might not allow these people to benefit, but then nothing in the criteria we've seen that says that that's true. So we'll have to see. And I think with that, I just wanted to flag for everybody. One of the things that we are going to be doing here from Joseph and Hall is we're going to be trying to put out some blogs on our website, and also some short videos that address really specific situations. Not to give legal advice. I think every case is going to have to be analyzed according to its circumstances, but just to flag kind of some considerations in different situations. And so I'd encourage people to stay tuned and take a look at our website, take a look at our newsletters, our blog, and you'll be seeing a lot of materials coming out over the coming days and weeks.
Well, with that, we're about 20 minutes in. I mean, all of our videos that are coming out are like 2-3 minutes, so it's not going to be a huge time commitment to look up your kind of specific circumstance. We're going to be doing these Facebook Lives pretty regularly over the next few weeks, English and Spanish, so keep an eye out for those. And keep an eye out for the blogs, keep an eye out for the videos that we put out. In addition, I guess one more thing I wanted to mention, for folks who we are doing these preparation cases for, we're certainly not taking on full representation at this time, since we don't know what the program looks like, but we are doing kind of these limited preparation cases. We're also doing a regular update kind of email to give folks, I guess, more timely advice about what's coming out, what do we know now, what recent updates have there been from the Department of State, from the Department of Homeland Security, from the White House. So just keeping people informed while we're also putting their cases together as best we can based off the criteria that we currently know. But I suppose besides that, I think like that was a good overview of where we're at right now, and we will be doing more of these. Anything else from either of you guys?
No, looking forward to getting more information from the Department of Homeland Security, and continuing to kind of consider different situations and get information out there to people.
And I think that maybe our proposed schedule right now is for streams on Mondays around the same time at noon, and then Spanish-speaking streams on Wednesdays at the same time, noon, Mountain Daylight Standard. I don't know which one it is right now.
Denver time,
baby. So yeah, if you want to see more streams like these and actually tune in live and ask us questions, those would be the times, at least right now, that we're thinking. And we'll be sending out emails that'll contain links and the times and those as well. And you can just check our Facebook page for those scheduled events as well.
All right, guys. Thanks.
Thanks, everybody. Have a great rest of your day, and hope to talk to you soon.
Thanks. Bye.